Okay. बस ठीक है आ गया in the green room. I request all to kindly be seated. I request our esteemed guests to kindly be seated.
I'm only taking the cue from you. You have to walk in front of him. Actually, the first cue will be just but don't switch it off. No, I'm going by you. I'm telling you that this is the sequence.
I would request all our esteemed guests to kindly be seated and put their mobiles on silent mode. Namaskar. Good evening, ladies and gentlemen. Our chief guest and guest of honor have arrived. It is a great honor on behalf of the Delhi International Arbitration Center to welcome you all to the Delhi Arbitration Weekend. We shall commence the program with the playing of the national anthem. I request all to kindly rise for the national anthem.
पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उज्जल जलधि तरंगा तब शुभ नामे जागे तब शुभ आशीष मांगे गाए सब जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे।
On behalf of the Delhi International Arbitration Center, I extend a special welcome to our chief guest, Honorable Dr. Justice D.Y. Chandrachud, Chief Justice of India, whose gracious presence here today is a testament to the importance and relevance of arbitration in the legal and commercial landscape in India. Our most heartfelt welcome to our guest of honor, Lord Peter Goldsmith, Chair of European and Asian Litigation, Debevoise and Plimpton, former Attorney General of England and Wales and Northern Ireland, a known name in the world of arbitration. Our warmest welcome to all honorable judges of the Supreme Court and High Courts and all other distinguished invitees and dignitaries present. To our foreign delegates, welcome to the vibrant city of Delhi. The lighting of the ceremonial lamp symbolizes a blessed beginning. As the Sanskrit shloka goes, Shubham karoti kalyanam, arogyam dhan sampada, shatru buddhi vinashaya, deepa jyotir namastute. Meaning, symbolically, just as light dispels darkness, knowledge dispels ignorance. The jyoti or the flame of the lamp helps create sankalp shakti, the power of intention, which enables us to invoke positive energies. Thus, salutations to the lamp. I request our chief guest, Honorable Dr. Justice D.Y. Chandrachud, and guest of honor, Lord Peter Goldsmith, to kindly grace the stage for lighting of the lamp. I request Honorable Mr. Justice Satish Chandra Sharma, Chief Justice, High Court of Delhi, Honorable Mr. Justice Siddharth Mridul, and Honorable Mr. Justice Vibhu Bakhru to kindly join in the lighting of the lamp. This way. Thank you, sirs. The capital of India, Delhi, is a home to a thriving arbitration community with a large number of experienced arbitrators and practitioners handling an ever-growing docket of domestic and international arbitrations. The maiden edition of the Delhi Arbitration Weekend is symbolic of our commitment to the fair and efficient resolution of disputes through arbitration, to deepen our understanding of the practice and principles of arbitration, and to explore the latest developments and trends in this field. May I now request Honorable Mr. Justice Vibhu Bakhru, Chairperson of the Delhi International Arbitration Center, to kindly deliver the welcome address. No.
We are honored to have amongst us Honorable Dr. Justice D.Y. Chandrachud, Chief Justice of India. His presence here today adds heft and quality to the deliberations and interactions. On behalf of all of us here, I take this opportunity to extend a very warm welcome to you, sir. I welcome the distinguished judges of the Supreme Court of India and Mr. Venkat Ramani, the Attorney General for India. I extend a hearty welcome to our guest of honor, Lord Peter Goldsmith, KC, whose contribution to the field of law is truly remarkable. A warm welcome to Honorable Justice Satish Chandra Sharma, Chief Justice, Delhi High Court, and the Patron-in-Chief, Delhi International Arbitration Center. He has been a constant source of encouragement for us. My fellow judges from the High Court, the Additional Solicitors Generals of India, former judges of the Delhi High Court and other courts, senior advocates, Mr. Mishra, President of the Bar Council of India, Mr. Manan, President, Bar Council of Delhi, Mr. Mohit Mathur, President and other office bearers of the Delhi High Court Bar Association, members of the media, ladies and gentlemen. Good evening and a very warm welcome to the first edition of the Delhi Arbitration Weekend organized by the Delhi International Arbitration Center. The Delhi Arbitration Center was established in November 2009. It holds the distinction of being the first court-annexed institution arbitration center. I would like to share some data to give you a sense of how we have grown the past decade or so. In 2009, the Delhi International Arbitration Center received 3 referrals. The number increased to 139 in the year 2014 and to 133 in the year 2019. In 2022, we got 2,106 referrals. In 2015, 2,162 hearings were held at the center. By 2019, the same had more than doubled to 5,829 hearings. This hearing alone, more than 520 hearings have already been held. The Delhi International Arbitration Center has recently framed a new set of rules that come into effect from 1st April 2023. The new rules now provide for scrutiny of draft awards. The arbitral tribunal would require to submit the draft award to the coordinator for scrutiny by a committee before delivering the same. The draft award would be reviewed for typographical errors, better formatting, and to flag any issue that the arbitral tribunal may have overlooked. The comments of the committee would be forwarded to the arbitral tribunal for its consideration. We believe that this would improve the quality of awards emanating from arbitrations administered by the center. We strongly feel that it is necessary to breed in an environment of accountability and transparency. The new rules now provide for publishing of the arbitral awards on the center's website. However, any of the parties can at any stage prior to publication opt to keep the award confidential. We are committed to provide access to quality arbitrations notwithstanding the value of the disputes are low. Therefore, the arbitral fee for disputes of a low value have been pegged at a bare minimum. However, the arbitral fee structure for high-value disputes was recently amended to increase the cap. It is now significantly higher than the fees under the 4th schedule to the Arbitration and Conciliation Act 1996. I'm also delighted to share with you another important initiative. The Delhi International Arbitration Center has partnered with National Law University Delhi for conducting diploma course in law and practice in arbitration. The purpose is to enable capacity building and enhance competence amongst arbitration professionals. The Delhi Arbitration Weekend is yet another initiative to act as a catalyst in bringing together professionals in the field of arbitration on a single platform for a dialogue on various aspects of arbitration law. We have 69 foreign delegates participating from 14 countries. The speakers are some of the most distinguished professionals in the field of law. The idea to hold a conference of this scale was seeded in the later part of last year. I vividly recall walking into the chambers of our Chief Justice for his approval for holding this event. I had been playing in my mind various arguments to persuade him to give me a go-ahead. But the conversation with him was rather short. I told him that we wanted to host a conference, and he, without blinking an eye, said, "Go ahead." All of us who have practiced as counsels know the rule that if a judge is deciding in your favor, terminate your arguments immediately, lest he changes his mind. Therefore, I promptly thanked him, exited his chamber. I then placed the proposal with the arbitration committee. We fixed the dates for the event and constituted the organizing committee under the chairmanship of Justice Rekha Palli. The OC galvanized into action sometime in September last year. The executive committee and the working committees were constituted sometimes later. The members of these committees, along with a committed band of volunteers, have worked tirelessly to put this event together. I can say it with confidence that it is truly a labor of love. They all have day jobs. I truly hope this maiden edition of Delhi Arbitration Weekend, a curated event spanning over 3 days, is intellectually stimulating and encourages the participants to meet, engage, and share their points of view. Thank you once again, and a warm welcome you to all. Jai Hind.
Thank you, sir, for setting the tone of the conference. May I now request Honorable Mr. Justice Satish Chandra Sharma, Chief Justice, High Court of Delhi, and Patron-in-Chief of the Delhi International Arbitration Center, to kindly address the august gathering.
Honorable Dr. Justice D.Y. Chandrachud, the Chief Justice of India, a guest of honor for the evening, Mr. Peter Henry Goldsmith, former Attorney General for England and Wales and for Northern Ireland, Honorable Judges of the Supreme Court, Honorable former Judges of the Supreme Court, my assistant brother judges serving on the bench of this court, Honorable former Judges of Delhi High Court, Brother Justice Vibhu Bakhru, Chairperson, Delhi International Arbitration Center, members of the Arbitration Committee, Shri Mohit Mahathur, President and other office bearers of Delhi High Court Bar Association, judicial officers of the District Judiciary and officers of the High Court, senior advocates, members of the bar, and all others who are in attendance today. With great delight, I extend a very warm welcome to all the dignitaries, speakers and participants at Delhi Arbitration Weekend. A brainchild of the Delhi International Arbitration Center, this 3-day conference is going to be a confluence of some of the best legal minds from across the world. The entire effort is being put in recognition of the fact that the arbitration has acquired the center stage in the global dispute resolution process. We live in a world in which the reality of globalization often finds itself in a confrontation with municipal laws, municipal systems, wherein different legal regimes control the fate of commercial transactions having a multinational bearing. In such a scenario, the true impact of global partnership could not be realized unless we adopt a uniform system for dispute resolution. Such a system may differ in its shape and form from one jurisdiction to another. However, it must be based on a common jurisprudential ground. Looked at in that sense, international arbitration has emerged as a great unifying force which has invariably infused the element of trust building in commercial transactions. Today, we stand in recognition of the unifying effect of arbitration as a model of dispute resolution. Ladies and gentlemen, I must take this opportunity to share that the dispute resolution in India is not a discovery of the present century. We had in this country what could safely be referred as the ancient system of dispute resolution. Since time immemorial, village councils have been first form and first forum of dispute resolution for a significant rural population of this country. I'm not sharing this without a reason. I do so because I'm reminded of the underlying element that formed the basis of an ancient system, that is element of trust. Even today, the efficacy of arbitral proceedings is based on the foundation of trust, the trust that parties impose in the arbitrators and the arbitral institutions. Let this conference not only be a platform for evolving and adopting the best arbitral practices from across the world, but also a timely reminder in advancement from the ancient to the modern, with only constant being the element of trust in the dispute resolution process. I congratulate the Arbitration Committee, officers and officials of Delhi International Arbitration Center for successfully conceptualizing and materializing this conference. With this, I conclude my address and wish all the participants a fulfilling experience here at Delhi Arbitration Weekend. Thank you and Jai Hind.
Thank you, sir, for sharing your valuable insights. I might now request our guest of honor, Lord Peter Goldsmith, to kindly deliver the special address.
Well, good evening to everybody. It's a very, very great pleasure to be here with so many distinguished members of the Indian legal profession and others. Honourable Chief Justice of India, Justice D.Y. Chandrachud, honourable members of the judges of the Supreme Court and former members of the Supreme Court, Attorney General of India, Chief Justice of the Delhi High Court, judges of the High Court, additional Solicitor Generals, senior advocates, members of the bar, everybody, we are here today committed to a sole cause, this arbitral conference. Justice Rekapali, forgive me, this has been an extraordinary event already, and I'm delighted to be a part of it. I'm going, if I may, also to give a special thank you to Mr. Tejas Karya, who is the person who's particularly responsible for getting me here, and I thank him for that. 3 years ago, I had the privilege of speaking here in Delhi. I spoke then about the essential rules for counsel preparing for an international commercial arbitration. Of course, a lot has happened in the world since then, not least the pandemic, which I know has affected the personal lives of a number of us. And for better or worse, those events have also brought about a number of global changes. One of those changes, which is undoubtedly for the better, is India's increasingly prominent global economic status. Just two parameters demonstrate this. First, India has overtaken the United Kingdom to become the world's 5th largest economy, and by 2030 it could be the 3rd largest. I think that's a clap for India rather than for me. India is poised to be the world's most populous country in April this year, surpassing China. And that brings with it both jubilation but also challenges, I know, particularly in the legal field. So India's rise as a global economic power continues with increasing investment both inside and outside the country. And this growth has meant there is increasing demand from the international business community to have access to an efficient, reliable, and final way of resolving disputes related to India. And I talk particularly about the international business community. In a sense, that's what I know best. Given that the Indian domestic court system is occupied, I would say rightly, with a heavy caseload, dealing with the day-to-day litigation of 1.4 billion people, hard for me to comprehend how great that is, the demand from the business community to resolve their commercial disputes can only be met outside the domestic court system. And so it seems to me it's in that context that India strives to establish itself as a leading hub for international arbitration and to emerge as the center of gravity for disputes that currently might otherwise go to Singapore, London, Paris, or Dubai. It's the pursuit of that goal that I would like to speak about today. Well, India's ambition to be a leading hub for international arbitration has been clear for a number of years. From my perspective as an international arbitration practitioner, India is closer than ever to achieving this goal. Indian arbitrations are being increasingly seated in India, and this will no doubt continue. But this evening, I want to consider how India can ensure that it is viewed as a viable pro-arbitration seat for international commercial disputes, whether there is an Indian connection or not. And with that in mind, I want to split the remainder of my speech into two parts. First, the solid foundation that India already has, and second, 5 key areas that I think will be critical to India achieving its goal of being a leading hub for international arbitration. So first, the foundations. For any country to become a leading hub for international arbitrations, it requires a strong foundation. In my view, respectful, is that India's foundation has been strengthened over the years, and 4 aspects of that seem to me particularly worth noting. First, India has an exceptional bar of advocates and solicitors with a slew of major domestic firms boasting strong dispute resolution and commercial arbitration practices, as well as all those who practice from chambers. The strength of the Indian legal profession is well known, increasingly attracting international attention and global law firms. I've had the privilege of often working with, sometimes against, Indian lawyers, and I know from experience that they make both outstanding teammates and formidable opponents. Second, India's judicial decisions today are increasingly pro-arbitration compared to the past. And in this way, the Indian judiciary, to whom I pay tribute, is continuing to play a very active role in providing critical support for the arbitral process. Indeed, in the last 5 years alone, the Supreme Court and High Courts have grappled with a number of important arbitration issues, including determining the seat of arbitration when an arbitration agreement expressly provides only for the venue, the ability of parties to choose foreign law to govern an arbitration agreement between them, and the ability of 2 Indian parties to choose a foreign arbitral seat in their arbitration agreements, even if the subject matter of their contracts and counterparties are fully situated within India. Honourable Chief Justice, thank you, D.Y. Chandrachud has of course himself been involved in a number of important arbitration-related judgments, including Zhejiang Bonley Elevator Guide Rail Manufacturers against Jade Elevator Components, Arbitration Petition Civil number 22 of 2018, which confirmed that where a contract allows the parties the option of approaching either an arbitral tribunal or the courts without providing any priority between them, the parties will be referred to arbitration. Or secondly, ONGC against Alfcon's Gunamasu JV 2022 SCC 1122, which confirmed a tribunal's ability to determine its fees in domestic ad hoc arbitrations. Well, this, if I may say so, is unsurprising given his astonishing judicial career, in the course of which he has, during his Supreme Court career alone, written, and I haven't counted myself, this is what I'm told, over 500 judgments and sat on over 1,000 benches, including the highest number of constitutional benches. Thirdly, India's government is invested in building the legislative and institutional support required for arbitration to thrive. And that's clear from 3 things. The legislative intervention of Parliament, which would be aimed at bolstering India's arbitral framework, the 2019 and 2021 amendments, in particular, are aimed at promoting institutional arbitration in India and at promoting India as a hub of international commercial arbitration. And secondly, the New Delhi International Arbitration Centre, which I'm so happy to be celebrating today, the objectives of which are all geared towards developing the IAAC, as it now is, as a leading institution for international and domestic arbitration and to creating an independent and autonomous regime for institutionalized arbitration. And thirdly, state governments, including those of Maharashtra and Telangana, have put in place policies for government contracts above a certain threshold to have institutional arbitration in place. The 4th factor I would single out is that India benefits from a common law tradition and history, which allows it to benefit from jurisprudence elsewhere, and indeed to influence jurisprudence elsewhere. The very foundation of India's laws, the Constitution of India, is sometimes referred to, I know, as a cosmopolitan document, because it derives several of its features from foreign sources, including the UK, Ireland, the US, and Canada. In this outward-looking tradition, Indian courts regularly consider and rely on international legal principles and judicial decisions of other, mostly common law, jurisdictions while dealing with social, economic, environmental, governance, and contractual issues. This willingness to be outward-looking and flexible to the changing needs of the law stands India in very good stead. Making the point, if I may add, that this is done with regard to the decisions of other common law countries while recognizing the special challenges and traditions of India. So if that is right, as a strong foundation, the question is, how does India build on that foundation to fulfill this ambition of being a leading hub for international arbitration? It seems to me that the most straightforward and most certain way to answer that question is to look to other leading seats, London, Paris, Singapore, and Hong Kong, and to establish what has enabled their success. India can then consider those aspects and how they can be incorporated in the context of its own ecosystem and arbitral landscape. It is that exercise that I will attempt to undertake this evening with the hope of providing what I see as a potential roadmap towards that goal. So to be able to add itself to the list of leading hubs of international arbitration, I'm going to single out 5 key areas that India will need to ensure that it is on a level footing with the other leading seats for international arbitration. Those are recognition of party autonomy, strong homegrown arbitral institutions, arbitrators' independence and impartiality, adapting international best practices, there's already been a reference to that this evening, and innovation. Let me just deal with each of those briefly in turn. In 2015, I co-authored the Chartered Institute of Arbitration Centenary Principles, which provides principles for an effective and efficient seat in international arbitration, and which I think provides a roadmap for any jurisdiction looking to establish itself as a hub for international arbitration. Let me then, for tonight, simply focus on the fundamentals I think India will need to bolster given the foundation that it already has. Well, first of those is recognition of party autonomy. That's the backbone of international arbitration. What do I fundamentally mean when I say party autonomy? I mean respecting parties' decisions to arbitrate their disputes, but also to choose the forum and governing law and process that will govern those arbitrations. I also mean recognizing and respecting the parties' freedom to choose their own arbitrators and indeed advocates. And this will be crucial for fostering the trust and confidence necessary for the international business community to seat their disputes in India. India will need to ensure, therefore, that there is a framework in place that gives business confidence that they'll be able to resolve their disputes and that their choices in these key aspects will be respected in India by courts and arbitrators alike. Well, we have, of course, seen positive steps towards this already. One of the most welcome developments is the relatively recent Supreme Court decision of PASI Wind Solutions against GE Power Conversion India. Following that decision, the Indian parties can choose a seat outside India, and in an arbitration between Indian parties that is seated outside India, any award will be considered a foreign award and enforceable under the New York Convention. That's critically important. In another decision, the Delhi High Court in Dolly Spintex and Louis Dreyfus recognized that Indian parties could have a foreign law governing their arbitration agreement. It's precisely these sorts of jurisprudential developments that will catch the attention of the international business community and encourage them to think about seating their disputes in India. But it will be vital to ensure that that positive trend continues moving in the right direction. So it's important, I would suggest, to consider 2 points in particular. One is the role of the Arbitration Council of India, which will be an independent body, nominated, appointed by the central government. The 2019 amendments envisage the Arbitration Council being responsible for a number of things, including framing policy and guidelines for professional standards, creating arbitral institutions, and accrediting arbitrators. This is a broad mandate, And it seems clear that the Arbitration Council stands to play a large role in the future of Indian arbitration. And during my speech, I want to touch on the potential impact of the broad mandate of the Arbitration Council, but now I make two brief comments. First, that while there may be examples of a body of this kind being engaged in promoting arbitration, for example, Japan's Ministry of Justice, I can't think of an example in an arbitration-friendly jurisdiction where such a body is also charged with regulating it. It seems to me that this is because the business community puts considerable weight on the autonomy of the arbitral process, that is at the very least at risk of being significantly eroded where a government body or regulator becomes involved. Secondly, and relatedly, I can see a real risk that if there are signs that the Arbitration Council's mandate will end up cutting across parties' autonomy and control over the arbitral process, that could lead to businesses removing India from its list as a potential seat for their disputes. I will express my reservations about the Arbitration Council previously, and I will not further detail and repeat them. For present purposes, what I will say is that while this is not an initiative that I would generally consider to be arbitration-friendly, I can understand the rationale in the context of the Indian landscape. Well, this is now on the statute book, and careful consideration will need to be given to how the Arbitration Council could help in supporting India's pro-arbitration ambitions. My second point relates to India's approach to confidentiality. The choice of international parties to arbitrate, I'm going to say invariably, includes a choice to keep that dispute out of the public eye. It's a prime example of the kind of autonomy that makes arbitration so attractive for resolving disputes. In support of that autonomy, the 2019 amendments provide for the kind of blanket confidentiality that businesses have come to expect. And that, I would suggest from their point of view, is a very welcome change. The confidentiality of the arbitral proceedings is, in my view, an attribute which the judiciary can strengthen. For example, where court proceedings arise out of arbitrations, as they often do, could the judiciary consider whether the hearing of that should take place under some form of confidentiality or privacy arrangements? Whether the judgment, for example, should be anonymized, something frequently considered in the United Kingdom? While I'm acutely aware of the heavy caseload of the Indian judiciary, there are no doubt circumstances in which confidentiality and anonymization are implemented in Indian courts, particularly, for example, in family matters. It's therefore, I would suggest, not something completely novel to the courts. If the confidentiality of arbitral proceedings was extended to court proceedings, I think it would give confidence to international parties that their failed business deal or financial difficulties will not be out there for the whole world to see. Of course, there may be cases where confidentiality is not required, but giving parties the option is yet another way to respect party autonomy and their decision to arbitrate. My second point, strong homegrown arbitral institutions. There are over 35 arbitral institutions in India, it is said. Now, institutional arbitration has received extensive support from the Indian judiciary, with High Court annexed international arbitration centres such as here in Delhi, in Gujarat, in Orissa, and the Chandrachud Arbitration Centre. Now, the novelty of court-annexed arbitration institutions may give international parties reason to pause, as they're accustomed to independent arbitral institutions that function outside the domestic court system. Moreover, as Justice B.N. Sri Krishna noted in his invaluable, indeed seminal, 2017 report, the quality of these institutions varies in terms of efficiency and speed, on-site infrastructure, available arbitrators, and quality of the awards made. One of the core aims of the 2019 amendments was to strengthen these institutions. And this aim was very much pushing at an open door, acknowledging as it does that institutional arbitration is really the only way to attract foreign parties to include India as the seat in their arbitration agreements. Well, the Arbitration Council is set to have a key role in this area, as it will be charged with the policies for grading institutions. which the Supreme Court of India and the High Court will be able to designate to appoint arbitrators, where the parties cannot agree on whom to appoint. Well, I can see that these amendments will help in lifting the burden of arbitral appointments from the purview of the courts. The appointment of arbitrators being undertaken by designated arbitral institutions would bring India in line with international standards, and limiting judicial intervention in the appointment process should in theory improve efficiency. Again, though, this will require careful handling. In particular, while there are criteria for grading by which that grading is to be done, for example, infrastructure and quality and caliber of arbitrators, there is inherent risk in the almost unavoidable discretion that goes into such a grading. That is where I think the Arbitration Council can provide significant benefits. That is because, unlike a number of other leading jurisdictions, India has a number of cities that could contend to be the seat of arbitration, but to a large extent they require benchmarks and harmonization. So the Arbitration Council could have a strong positive role to play in establishing those benchmarks and consequently in their harmonization, with the result that businesses can expect a greater level of certainty with respect to the various Indian arbitral institutions. Therefore, while there may be some reservations in the business community with respect to interference, there may now be an improved platform for ensuring that India benefits from strong, homegrown arbitral institutions. But to provide this, the Arbitration Council's mandate in this regard will need to be executed with those reservations in mind and with the aim of reducing judicial intervention in the arbitral process. Let me turn then to access to high-quality, independent and impartial arbitrators. Well, it's not an overstatement to say that for India to become a leading hub for international commercial arbitration, the international arbitration community must have access to high-quality, independent and impartial arbitrators, both as a matter of fact and of perception. High-quality arbitrators, to some extent, in the eye of the beholder. Some, for example, prefer the rigor and gravitas that is often brought by retired judges. Others look for arbitrators who not only have a good knowledge of the law, but also have the benefit of relevant industry or commercial experience. But it's not so much the characteristics of what a high-quality arbitrator is that I want to stress, and which I think many would agree, independent and impartial and so forth. Like the parties that India is seeking to encourage to seat their arbitration in India, high-quality arbitrators are scattered around the world. As with India's potential to be an international arbitration hub, there's huge potential for Indian lawyers and judges to become arbitrators that are in demand across the globe. This potential is, at the moment, unrealized. While I hope this changes in coming years, it's likely that international parties will wish to look internationally for those that will arbitrate their disputes. Indeed, that's the case in all leading arbitral seats. London-seated international arbitrations, for instance, seldom see the appointment of the 3 arbitrators that are all English qualified and based in the United Kingdom. It's with that in mind that in my 2019 speech, I offered a heavy caution with respect to the then proposed and since enacted 8th schedule, which would have effectively excluded foreign arbitrators from sitting as arbitrators in any Indian-seated arbitration. In particular, I was concerned that foreign businesses, and I quote from what I said, would not be prepared to sign up to agreements providing for Indian arbitration if they will not have the choice to appoint arbitrators from jurisdictions with which they are more familiar, with significant consequences for Indian arbitration. I think those were quite widely shared, those concerns. It would be no surprise, therefore, that I was relieved to see that the 8th schedule was removed by the 2021 amendments, paving the way for parties to access a global pool of arbitrators. There is, however, reason to pause, as those qualifications, experience and accreditation norms for arbitrators remain to be specified by regulation, which will include regulations made by the Arbitration Council. Here again, the Arbitration Council has a potentially key role to play. It's of course not yet clear how the Arbitration Council will approach those regulations, so we must, as it's so often said, watch this space. But in the meantime, I just want to stress one point. Let's not go backwards. Whatever the approach taken to these regulations, party autonomy must feature front and center, And by that I mean, at the very least, making provision for parties to be able to appoint arbitrators from other jurisdictions, for example, that they're more familiar with. Adopting international best practices. Over the years, which has now been quite a long career, I've seen a number of international arbitration best practices develop. Just let me give you two examples. First, on the selection of arbitrators, and I've just mentioned, parties will wish to have access to independent, impartial, and high-quality arbitrators. I understand from Indian colleagues that conscious efforts are already being made by the courts and arbitral institutions to ensure that the best candidates are chosen, keeping in mind the subject matter of the dispute, amount of dispute, arbitrators' expertise and availability, and the requirements of the parties. For example, the DIAC has a distinguished panel of 454 arbitrators, which does comprise not just former judges, but also senior advocates, engineers, chartered accountants, architects, professors, and international arbitrators. That's good. And that exercise is very welcome, but less than 2% of the panel members are categorized as international arbitrators, while retired judges comprise approximately 65%. I hope these statistics evolve in the future to offer more diverse categories of arbitrators for appointment. This is not a plea for a job, by the way, but I think the Indian arbitration would benefit from the wider pool of people able to sit as arbitrators. The protection and immunity now offered to arbitrators in respect of legal proceedings under the 2019 amendments will also give further confidence to those who are already considering becoming arbitrators. But it will now be all the more important to continue to focus on related best practices. For example, the processes of interviewing prospective arbitrators, selecting a chair, highlighting conflicts of interest. Now, India has already gone some way on the third point by incorporating the IBA guidelines on the conflict of interest in international arbitration in schedules to the Arbitration Act 1996. Secondly, in ensuring that full autonomy is given to the parties to agree the rules of procedure. For example, one area where I understand it's common for tribunals in India to proceed as though they're in court is evidence, or sometimes so to proceed. But as with all aspects of arbitration, parties considering India as a seat will expect to have flexibility and control over their proceedings and align with international practices when it comes to issues of procedure and evidence. The importance of this was emphasized over a decade ago by the Supreme Court in Salyadri Earth Movers and L&T Finance, where the court noted that, quotes, the power of arbitral tribunal to determine the admissibility, relevance, materiality, and weight of any evidence just cannot be overlooked, close quotes. Further, in Stray Infrastructure and Tough Drilling, the Supreme Court confirmed that while a tribunal may, quote, draw sustenance, close quotes, from the fundamental principles underlying the Code of Civil Procedure, or the Indian Evidence Act, the tribunal is not bound to observe the provisions of the CPC and, by extension, the Evidence Acts. In my view, it would be most attractive to international parties if tribunals were encouraged to use, for example, the IBA rules on the taking of evidence in international arbitration, which are well tested and have worked well. In 2016, a report confirmed that nearly half of arbitrations worldwide reference the IBA rules of evidence, with common arbitral seats such as Singapore, England adopting them in the vast majority of arbitrations, 78 and 70% respectively. The same report found that those rules were referenced in only 33% of proceedings in India, and that they were considered binding in only 50%. I'm sure that that percentage has increased in the past 7 years, but anecdotally, my understanding is it could do with being improved much further. All of that is to say that adopting international best practices, as has been referred to already, will provide a sense of stability and familiarity to international parties considering whether to make India the seat of their dispute, and it will encourage them to consider Indian cities as a viable option and turn their back, for example, on Singapore and London. Finally, I want to say a word about innovation. I had an interesting discussion with the Honourable Chief Justice this evening about what is happening with technology in the Indian courts. It's extraordinary and much to be admired. But looking across other jurisdictions, most leading seats are innovative, in the sense they're ahead of the curve in responding to the needs and demands of the international business community. Can I just give you 3 examples? First, India's decision to legislate and adopt timelines for arbitrations. That's a way of solving a uniquely Indian problem with a uniquely Indian solution. Timelines have been implemented by a number of arbitral institutions, including the International Chamber of Commerce, and the ICC and the Stockholm Chamber of Commerce, in response to user demands for streamlining and time and cost efficiency. But in India, given the wide prevalence of ad hoc arbitrations, the concern was that there would be no supervision or administration of these arbitrations. To improve the situation, and in an attempt to rebut the presumption that proceedings in India are infamously long, the 2015 amendments to the Arbitration Act introduced timelines for arbitrations. And I understand from Indian colleagues that the timelines have been largely successful in making ad hoc arbitral proceedings more efficient. Of course, as the institutionalization of arbitration increases, and as better institutions have more oversight over arbitrations, I expect and hope that these timelines will play a lesser role in due course. However, as international arbitrations are usually administered by institutions and can be more complicated, these timelines are not strictly necessary for international arbitrations. Recognizing this, the 2019 amendments replaced the time limits with a more gentle guideline. The parties, quotes, endeavor, close quotes, to complete international arbitration matters within a period of 12 months from the date of completion of pleadings. In my view, that was the right decision. Secondly, during and after the pandemic, India has been quick and adept at adopting technology in the context of international dispute resolution. And I understand that despite no longer being restricted by COVID regulations, Indian courts continue to hold virtual hearings. I've already referred to that issue this evening. It shows to me that India is willing to adopt technological solutions to issues. One problem that relates to the technological infrastructure in India is transcription of evidence. International parties, I tell you, are used to having real-time transcription, used all the time in hearings. I understand that India still relies on service providers from Singapore and London to either travel to India to attend the arbitration hearings or to join them virtually for real-time transcription. This can be quite expensive and, of course, quite inefficient. Recently, I understand that Indian players have started to provide transcription services close to internationally prevailing standards by using different technological advances. Well, this is encouraging, and I believe there's a lot of scope to find homegrown solutions to a number of these technological and infrastructural issues. Third, the Indian judiciary will need to continue to support international arbitration. That's, of course, the position outlined in Article 5 of the UNCITRAL Model Law, which provides that the courts should support but not intervene in arbitral proceedings. And part of the judiciary's ability to support international arbitration will turn on the judiciary's ability to innovate through grappling with difficult issues. And a recent example of this is Amazon against Future Retail, where the Supreme Court upheld the enforceability of an emergency arbitrator's order under the Singapore International Arbitration Centre rules, despite there being no express recognition of emergency arbitrators' orders under the Arbitration Act. By upholding the legitimacy and enforceability of emergency arbitral awards through a supportive interpretation of the Arbitration Acts, the Supreme Court has promoted the principle of party autonomy and institutional arbitration. The decision also further reduces the need to approach the court for urgent interim relief. Well, I look forward to seeing similar innovations in the context of international arbitration. India can further its ambitions as an international arbitration hub by thinking creatively and outside the box when it comes to issues that can otherwise appear to be roadblocks on a journey to becoming an international arbitration hub. Well, to conclude, I want to just make 4 final points, 2 reflective and 2 prospective. First, it's clear that India has a solid foundation from which to pursue its goal of becoming a leading international arbitration hub. Second, India is closer than it's ever been to reaching that goal. Dialogue with each other through conferences such as these will only help build upon that foundation. Third, while I'm confident that the recent amendments will encourage the international community to consider India as a seat for their arbitrations, it will be important that special care is given when it comes to the Arbitration Council's regulations, including making sure that they take account of the views of all potential stakeholders. If the ultimate goal is to make India a hub for international arbitration, the regulations of the Arbitration Council should also be consulted with the international arbitral community. Fourth, while the arbitration regime in India is important, it will be the execution and experience of the parties during the arbitral process that will dictate whether India becomes the hub that it seeks to be. As I see it, the most straightforward and certain way to ensure that experience is a positive one is the adoption of international best practices which are familiar to international parties. In the meantime, I know that all working in the international arbitration world will eagerly track India's continued progress. That is perhaps why this conference is so well attended, including from overseas. I look forward to continuing this conversation, perhaps playing a small part in India's journey to becoming an international arbitration hub. Thank you again for inviting me. Thank you for listening, and I wish the rest of this conference very, very well. Thank you.
Thank you, sir. We are honored to have had the opportunity to hear you, your thoughts and ideas on the issues before us in this conference. May I now request our chief guest, Honorable Dr. Justice D.Y. Chandrachud, Chief Justice of India, to kindly deliver the keynote address.
Lord Peter Goldsmith, former Attorney General of England, Wales and Northern Ireland, my distinguished colleague Justice Satish Chandra Sharma, Chief Justice of the Delhi High Court, Justice Vibhu Bakhru, Chairperson of the Delhi International Arbitration Center, thanks. Brother and sister judges of the Supreme Court and the High Court, High Courts, I should say, former judges of the Supreme Court and the High Courts, guests from abroad, organizing committee members of the Delhi Arbitration Weekend, and all of you present here this evening. Good evening. I'm delighted to be participating at the opening of the Delhi Arbitration Weekend of 2023. I congratulate the team of the Delhi International Arbitration Center in putting together this unique congregation of the leading experts and practitioners in the arbitration community from world over here in Delhi. I believe that events such as the Delhi Arbitration Weekend immeasurably strengthen our own arbitration ecosystem. We have over this weekend the benefit of learning from our colleagues and enhancing our systems from best practices developed across the world. But let me begin by saying how truly amazed I am by the depth, sweep, and all-encompassing reach of the address by Lord Peter Goldsmith. Having heard that address, I guess that for all of you from the arbitration world, the award of the evening is the cultural evening that follows my address. Yet you stand temporarily injuncted, first by a division bench of my colleagues in the Delhi High Court, and now by a judge of the Supreme Court. However, I'm also looking forward to the performance by Kalapini Komakali. There's something personal there as well. My late mother was a trained classical singer who performed for the All India Radio. The radio then was our source of news, views, and entertainment, much before our lives came to be governed by algorithms, social media, and the internet. Some of my cherished childhood memories are of sitting next to my mother while she practiced her ragas every evening. So I begin by allaying your fears of a sonorous imposition of judicially designed boredom. This court, albeit outside the courtroom, shares your concern of expeditiously enforcing the cultural award which is to follow. Listening to good music, much like reading an interesting award, comports with public policy. As this evening demonstrates, a wholesome combination of both ought to nurture the sensibilities of the arbitration universe. That India and our courts are a part of this universe is a matter of pride, which I share with the organizers of the Delhi Arbitration Weekend. Humor aside, I begin today by emphasizing that though India has a checkered history with arbitration, we have made legislative and judicial amends to move towards being a pro-arbitration jurisdiction. This does not mean that there is no judicial intervention in arbitration. Speaking for myself, I am not particularly a votary of the idea that all judicial intervention is negative. While some of you may prefer a self-effacing judiciary as opposed to an interventionist one in this area, I believe courts ought to play an important role in ensuring an effective arbitration ecosystem by stepping to protect independence as well as impartiality of arbitral proceedings. Courts can and indeed do serve as effective supporters of the arbitration universe. Not the least of those interventions is to ensure that when the state, as the largest litigant, enters upon arbitration, it must abide as much by the letter of the law as by the spirit of arbitration. The French arbitration law, for instance, phrases the role of the judge as judge acting in support of arbitration. This is the spirit with which judicial intervention should take place vis-à-vis arbitration. Over the last few years, our courts have been consistently applying the law which has been modified by the legislature to ensure that in an era of climate change, the arbitration ecosystem remains green to its core and its soul. When I came back from Harvard and began my practice in the 1980s, the arbitration law in India was not governed by a single piece of legislation, but by 3 separate legislations. The Arbitration Act of 1940 dealt with the enforcement of domestic arbitral awards. The Arbitration Protocol and Convention Act of 1937 dealt with the Geneva Convention awards. The Foreign Awards Recognition and Enforcement Act of 1961 dealt with the awards under the New York Convention. It did not merely add further confusion to a field where conflict of laws was already an issue, with courts often muddling between governing law, substantive law, and the law of the seat of arbitration. But these laws also faced widespread criticism for the consistent judicial intervention they allowed and encouraged at multiple stages of the arbitration process. This led to the Supreme Court taking note of the issues with this regime and noting that the manner in which the proceedings under the Act were conducted and without exception challenged in courts has made lawyers laugh and legal philosophers weep. The philosophical reflections of the Supreme Court were not inappropriate. One of the parties to that litigation was aptly named after the spiritual and moral voice of the nation, Guru Nanak Ji. In many of the arbitrations that I was personally involved as a lawyer during that time, dealing the process by consistently inviting the intervention of the court had almost become a best practice. Lawyers for one of the parties would find disingenuous strategies to delay, defeat, and grind commercial claims to dust. Commercial ventures would waft between the dusty files of lawyers' shelves to the dust of commercial oblivion. One of the last few cases before my appointment to the bench was a commercial arbitration. My client, a French company, secured an award only to be faced with a moratorium under then omnipresent Sikh Industrial Companies Special Provisions Act. My client, I doubt whether my client made much money in the arbitration, that I certainly formed an abiding friendship with the counsel on the other side, Justice Shavak Swajidar, who has become a friend forever. Well, lawyers will always have the last laugh, but I think we also need to make the business community rejoice. A few years before I was appointed as a judge of the Bombay High Court, the Arbitration and Conciliation Act 1996 was promulgated, with a vision to do away with the issues of the earlier regime and transform India's image as an arbitration-friendly country. The 1996 Act was largely based on the ancestral model law, which reflected the prevailing consensus on the best practices in arbitration across the globe. Part 1, as we know, of the 1996 Act dealt with domestic arbitrations, while Part 2 dealt with the enforcement of foreign awards. Unfortunately, the progress of the advances through the spirit of the 1996 legislation was overshadowed by some of the judgments on the judicial side. Through Bhatia International of 2002 and Venture Global in 2008, the Supreme Court held that Part 1 of the Act would be applicable to arbitrations which took place outside India and to foreign awards unless the parties explicitly excluded their provisions. This led to the interference of Indian courts and foreign awards being set aside. Another setback was through the expansion of the grounds on which an arbitral award could be set aside under Section 34. Section 34 allowed the setting aside of an arbitral award inter alia if the award was in conflict with the public policy of India. In line with international practice, the term ought to be read in a restrictive manner. However, my judgment as a judge of the Bombay High Court, dismissing a challenge to an arbitral award, was set aside by the Supreme Court in, may I say, the infamous decision in ONGC versus Saw Pipes in 2003. This is therefore a constant reminder to me that the Supreme Court is not final because it is right, but it is right because it is final. The Supreme Court held that a domestic award could be set aside if it found that it was patently illegal. In the view of the court, an award was to be considered patently illegal if it was contrary to the substantive provisions of Indian law or was against the terms of the contract as construed by the courts. This led to the courts venturing into the merits of an arbitral award and changed the dynamics of the role of the courts envisaged in the 1996 Act, which had made provisions for the court to only play a supervisory role and review the arbitral award only to ensure fairness. While these cases haunted the Indian jurisdiction for a period of time and led to it being considered as anti-arbitration in its sweep, we have now emerged from the shadows of those decisions. The decision in Balco has conclusively overturned the decision in Bhatia and Venture by restoring the mutual exclusivity of Part 1 and Part 2. The 2015 amendment, through the insertion of an explanation in Section 34, narrowed down the scope of a court's interference with an arbitral award on grounds of it being in conflict with public policy. Patent illegality was retained as a ground only for domestic arbitral awards arising out of arbitrations other than international commercial arbitrations. Further, the scope of patent illegality itself was narrowed, and the amended legislation stated that awards cannot be set aside merely on the ground of an erroneous application of the law or by the reappreciation of evidence. The 2019 amendment was another step towards enhancing the efficacy of the arbitration regime in India by introducing provisions for confidentiality of proceedings and envisaging the setting up of an Arbitration Council of India. Over the last few years, both judicial opinion and legislative change have been moving in the direction of making India an arbitration-friendly jurisdiction. In my concurring opinion in Ayaswamy, where we held that mere allegations of fraud simpliciter would not lead to ousting of the jurisdiction of the arbitral tribunal, I also discussed the spirit which should guide judicial decision-making in arbitration cases. As a fledgling judge of the Supreme Court, I was emboldened to write by the sagacious presence of Justice Arjun Sikri by my side, and we held that the basic principle which must guide judicial decision-making is that arbitration is essentially a voluntary assumption of an obligation by contracting parties to resolve their disputes through a private tribunal. The intent of the parties is expressed in the terms of their agreement. Where commercial entities and persons of business enter into such dealings, they do so with a knowledge of the efficacy of the arbitral process. The commercial understanding is reflected in the terms of the agreement between the parties. The duty of the court is to impart to that commercial understanding a sense of business efficacy. We stand today at an important inflection point for arbitration in India. While we have moved further towards being an arbitration-friendly jurisdiction, there is no doubt scope for improvement, as with any other jurisdiction. I would like to share some of my suggestions in this regard. First, we must ensure that parties appoint lawyers as arbitrators more frequently. Retired judges are doing amazing work in the arbitration space, but we cannot look only to retired judges when it comes to appointing arbitrators. There are many promising candidates who are overlooked in favor of a more established name, and this leads to the faulty perception that India does not have as many qualified arbitrators as it requires. DIAC's panel of arbitrators consists not only of retired judges, but also 48 senior counsel and 220 advocates. This is a welcome move. The arbitral space in India can do well to foster diversity in terms of source and experience. The experiential learning which a gender-diverse arbitral pool would bring to the process must also be emphasized. If the Indian legal system has to move away from the tag of being an old boys club, the arbitration space can add heft to the mission to provide equal opportunity to men, to women, and to them. Second, all stakeholders must work together to ensure that arbitration does not remain the choice of dispute resolution only for parties with large commercial ventures. Smaller businesses, as well as individuals, must be encouraged to include arbitration clauses in their contracts. Of course, this will also require arbitrations to be more affordable. The fourth schedule of the Arbitration and Conciliation Act 1996 goes a long way towards ensuring that arbitrations are accessible to all parties. That was perhaps one of the guiding principles in the ONGC judgment which we recently delivered. Thirdly, interim relief must be readily available to parties. The subject matter of the dispute must be preserved, and the grant of interim relief is often pivotal in this venture. Recently, in SR House Private Limited versus ArcelorMittal, the Supreme Court ruled that courts are not bound by the technicalities of the Civil Procedure Code of 1908 while adjudicating applications for interim relief under Section 9. This judgment underscores the importance of courts in ensuring that arbitrations are an effective form of dispute resolution. Turning now to a common experience in the world of arbitration, the COVID-19 pandemic acted as a catalyst in the adoption of technology in legal systems world over. India was no exception. With the onset of the pandemic, courts, as well as arbitral tribunals, transitioned to justice delivery models based on e-filing of pleadings and written submissions and the commencement of virtual hearings. Of course, as with any new system, there is growing pains and the limitations of the system were laid bare. But we must make every effort to view setbacks as opportunities for growth and modernity, rather than as sounding the death knell for the adoption of technology. It is also important to remember that reactive policymaking rarely results in the development of sustainable and bankable solutions. We must therefore anticipate our technological needs and build digital capabilities which are scalable. I hear that many domestic as well as international commercial arbitrations were conducted virtually during the pandemic. Virtual hearings come with many advantages. For instance, the parties bear a significantly lower cost than they otherwise would because they are not required to fly the arbitrators, their lawyers, their in-house counsel, and their witnesses, amongst others, to the venue of the arbitration. It also becomes significantly easier to settle upon hearing dates which account for the busy schedules of the various people involved in the arbitration, because the time taken to travel to the venue, which may be in a different country, is eliminated. However, virtual hearings also raise issues that deserve our serious attention. Technology is fallible. The virtual platforms which are used for these hearings may not be secure. Even when they are secure, hackers or other mischief makers may be able to hack into the hearing platform and access sensitive data. Many parties have also expressed concern about cross-examinations being conducted virtually, as arbitrators may not be able to discern the demeanor of witnesses. This in turn is thought to impact the reliability of witnesses. Some parties have evolved innovative mechanisms to maintain trust in the arbitral process by sending delegates to the opposite party's offices to observe the witnesses who are testifying. These concerns merit serious consideration, and I'm happy to note that they will be discussed in one of the sessions scheduled to take place this weekend, the topic for which is reimagining arbitration in a post-COVID world, the right to a physical hearing. A potential solution would be to allow for a combination of in-person and virtual hearings, depending on the exigencies which prevail at the time. Of course, it is not just parties, lawyers, and arbitrators who will have to grapple with these challenges, but also arbitral institutions. The Korean Commercial Arbitration Board adopted the Seoul Protocol on video conferencing in international arbitration, and the Hong Kong International Arbitration Center framed the HKIAC guidelines for virtual hearings. I would like to highlight a single aspect of both these guidelines in order to demonstrate their usefulness to virtual hearings. The HKIAC guidelines contemplate the appointment of an invigilator when witnesses are testifying remotely, and the Seoul Protocol provides that the arbitral tribunal may terminate the examination of witnesses through virtual means if it is of the opinion that it would be unfair to either party to continue. Measures such as these are essential to maintain the integrity of the proceedings before arbitral tribunals. I take this opportunity to encourage the Delhi International Arbitration Center to draft and adopt a protocol on virtual hearings, which is tailored to the Indian context. Indeed, every arbitration center in India would do well to adopt protocols in this regard, because the parties to arbitrations would be the biggest beneficiaries. The adoption of such guidelines will ensure that there is certainty in virtual hearings. It will also make the process of arbitration more efficient by averting protracted disagreements on procedural issues. Finally, it will also ensure that we do not unwittingly compromise on fairness. It is almost impossible to talk of technology in arbitration without speaking of transcription services. The advantage of real-time transcription needs no explication. While international commercial arbitrations have been employing real-time transcription services for many years now, domestic arbitrations are yet to catch up fully. I was quite pleased to hear that there are quite a few new local businesses which have recently begun to provide this service. I hope that domestic arbitrations will move forwards towards adopting transcription services as well, and we in the courts will not lag far behind. In one of my early arbitrations, my client was in contest with a solicitor who did not lack his bit of ingenuity. As the solicitor deposed in evidence, the judge would dictate what was said, not always without dispute. The initial hour or more of the next day would be spent in correcting the text of the evidence of the previous day. The arbitrator, a jolly good retired judge, was a stickler for grammar and spent much time in correcting punctuation. The solicitor who was a witness in his cause was no stickler for time, and so our arbitration meandered along the way. Things have, however, changed with institutions like the DIAC, which is why we are here to celebrate their cause and existence. Last but not the least, technology allows arbitrations to be conducted in a paperless fashion. The pleadings, written submissions, correspondence, and most evidence can be provided in the electronic format instead of in voluminous paper books. Here I must share two success stories with you all. The first is that hearings in the two cases of the Supreme Court, which were to be adjudicated by a constitution bench, have been conducted completely without paper. This is no small feat because most of the judges and many of the lawyers cut their teeth in the age of paper. Our efficiency in the process can save the environment just as it adds to the confidence of the community in our processes. And yet we have managed, all of us, to shed our sense of unease with technology that was not quite as familiar to us as it is to the younger generation. The second success story is that of the paperless courts in the state of Orissa, so ably guided by Chief Justice Muralidhar, a former judge of the Delhi High Court. As the name suggests, these courts function without physical paper books, and judges rely on digitized court records during these proceedings. Advocates are not required to file physical copies of paper books, and the state may be served with an e-copy of the paper book. 10 years ago, this would have been inconceivable, and yet today, it stands true. I choose to share these stories with you this evening to encourage everyone to move towards paperless hearings in international as well as domestic commercial arbitrations. There's a long-standing perception that courts are behind the curve when it comes to modernizing their processes. Perhaps there's some basis to this perception, but the instances I have narrated indicate that this is slowly but surely changing. Soon, the courts will be light years ahead in terms of technology, and domestic arbitrations may just be lagging behind. We have, in the course of the last few years at the Supreme Court, been emphasizing upon party autonomy. Party autonomy lies at the core of arbitration. But yet, let me sound a little note of caution, which is that party autonomy is not coextensive with arbitral anarchy, which really goes to highlight the importance of institutional arbitration. Unregulated adjudication, whether in the public or in the private space, has the potential to lead to high costs and unacceptable procedures. Regulation within the auspices of an institutional arbitration is the key to efficient, objective, and well-defined processes. User-centric legal services must prioritize user satisfaction and be responsive to their feedback. The second point which I want to make is that arbitration chairs have to be established across national law schools in India. We have to provide tutorials, videos, and FAQs for people who are not as conversant with the arbitration space and universe as all of you are here today. There is an urgent need for training of judges. Training judges apart from this hugely dynamic and well-researched group of judges who are present here today. But the world of judging lies beyond us, and we need to reach out to them by training them in the intricacies of arbitration. So very often in the Supreme Court, when I come across an appeal against a decision under Section 34, you find that the world has come a full circle. When judges refuse to deal with the merits of a matter at all and merely cite judgments which say that intervention is not warranted under Section 34. Now, both extremities are not desirable, and the essence of the judicial function must be to try and find a balance, to perhaps track that one case in a million where something had gone wrong. We need training for lawyers as well, because lawyers, as much as judges, need to be part of the process of this whole mission, of this whole movement, if the movement has to succeed. Arbitration then has an important role to play overall in fostering the rule of law? Well, lawyers' ingenuity knows no bounds. Recently, we had to deal with the argument that the dropping of timelines in international arbitration by the 2019 amendment was a substantive amendment and hence prospective in nature. The argument was that since the timelines were dropped, this was not procedural and therefore it would not be retrospective in character. And therefore the submission before us was that since the timeline had expired, an extension could not have been granted by the Delhi High Court. Well, we of course rejected the argument, but that goes to say how ingenious our arbitration bar can be and is. I believe that the Delhi Arbitration Weekend is a perfect opportunity for all of us to put our heads together and discuss some of the challenges and upcoming issues in the arbitration arena. I had the chance to glance through the schedule for the weekend, and the breadth of topics that are going to be covered is really impressive. One's peers and contemporaries are often the best source of learning, and events such as this will hopefully move the needle on the practice of arbitration. The discussions on these wide-ranging topics, from challenges in the arbitration ecosystem, party autonomy, diversity, and access in arbitration, to that on intervention of courts in arbitrations, will lead to a vibrant exchange of ideas and help all of us bring out the best practice from across the world. I have requested my judicial clerks to stay around for the panel discussions and brief me on any suggestions that can further the development of the arbitration ecosystem in India. I assure all of you that we are truly committed to further developing India as an arbitration-friendly jurisdiction and are looking forward to working towards any suggestions that may emerge from these discussions. Sharing our own failings is not an acknowledgement of the grass being greener in other jurisdictions. Acknowledgement of the errors of our past and the failings of the present is important in itself, for evolution becomes reality when we introspect and reflect. I once again congratulate the Delhi High Court and the Delhi International Arbitration Center for conceptualizing and organizing the Delhi Arbitration Weekend. I believe the success of this event is a mark of the reputation that the Delhi International Arbitration Center has built over the years. I'm hopeful that the Delhi International Arbitration Center will see many of you visiting it more often and for the purpose of participating in its work as professionals who arbitrate. But above all, your moral arc provides new pathways towards their and our excellence in the Indian judiciary. Thank you very much.
Thank you, sir, for initiating the Delhi Arbitration Weekend. Your words of wisdom have been inspirational and have added great value to the proceedings of the evening. Your presence has made this event truly special. With this, we come to the close of our inaugural session and shall be commencing the cultural evening after a short break of 10 minutes. Thank you.
request to kindly please take their seats. Good evening, ladies and gentlemen. Good evening, ladies and gentlemen. Welcome to the cultural program. I invite on stage our distinguished artist for the event, Ms. While we reflect on the scholarly views of our Chief Justice of India, Honorable Dr. Justice D.Y. Chandrachud, and profound words of Mr. Goldsmith, let us take some time to rediscover our roots in the rainbow of our rich cultural heritage. Music is the soul of all vibrations and the rhythm to the universe. As said by poet Christian Andersen, where words fail, music speaks. That being so, I invite you to bask in the moonlight of tunes. Shining bright in this star-studded evening, we have with us one of the finest classical vocalists of the younger generation, Miss Kalapal Konkali. Miss Kalapal is daughter and disciple of the legendary Pandit Kumar Gandharva and has been trained by illustrious Shrimati Vidhushi Vasundar Konkali. She took classical music to new heights and its appeals to the newer generation. Her contribution to the growth of the genre by adding to youthful imagination, thoughtfulness, and a mature command on the aspects of classical vocalism has received wide acclaim. Devoted to the promotion of art, Miss Kalapani has popularized classical music through musical festivals and lecture demonstrations. She is also an active trustee of Kumar Gandharva Sangeet Academy. She has widely traveled to different countries for her concerts and has received commercial success through musical productions. We are extremely happy, ma'am, that you consented to lead this musical journey. We welcome you wholeheartedly. I would now like to request Honorable Mr. Justice Siddharth Midil, Judge, Delhi High Court, to kindly felicitate Ms. Kalapani. sir. We also have with us Mr. Ramendra Singh Solanki. He is celebrated instrumentalist who has kept the nation enthralled with his craft. The man who has ridden and graved in his fingers. Mr. Solanki belongs to the Ajrara Gharana. He is son and disciple of Tabla Maestro Shri Ajay Singh Solanki, who is embodiment of discipline and principles in the field of music. He has received formative training from Ustad Nisar Hussain Khan of Jaipur. Mr. Solanki has widely traveled and has received numerous awards. I request Mr. Samir Jain to come on stage to felicitate Mr. Solanki. Thank you, Mr. Samir. We also have with us Mr. Niranjan Lele. Mr. Lele is a disciple of legendary Padam Shri Pandit Tulsidas Borkar. He has also extensively traveled abroad for many musical performances and workshops. We will find his music in various films and albums, including the short film Kulsoom, based on women empowerment, which won the Babasaheb Phalke Award and received special jury recognition for unique background music composed and played only on harmonium. Mr. Niranjan is an educator, an award creator, and has received more than 150 badges by completing online courses conducted by Microsoft Education. I request Mr. Umar Ahmed to come on stage and felicitate Mr. Niranjan Lele. Thank you, Mr. Umar. And finally, we have with us Mr. Anirudh Jain, a renowned percussionist whose mastery in the art of fame for leaving people spellbound. Mr. Anirudh Jain is an acclaimed artist, having been associated with All India Radio Doordarshan since the year 1978. He has worked on various projects with leading production houses and television channels. He has performed in international and domestic arena at prestigious events. I request Mr. Mohsin Khan to come on stage and felicitate Mr. Anirudh Jain. Thank you, Mr. Khan. We have now come to the most awaited moment. The remarkable and accomplished artists we met will now deliver solace and peace to our hearts through their performance. Let the cultural feast unfold itself. I request Madam Kalapani to kindly commence the event.
तानपुरा थोड़ा सा मॉनिटर में मेरे लिए बढ़ा दीजिए। इकडून झालंय वाढवून। सबको नमस्कार। बहुत आभारी हूँ दिल्ली आर्बिट्रेशन वीकेंड के अंतर्गत मुझे यहाँ बुलाया गया। मैं आज अपने गाने की शुरुआत शाम का एक राग है, उसका नाम है केदार। तो केदार राग में एक मंगलाचरण से करने जा रही हूँ। मेरे पूज्य पिता और गुरु पंडित कुमार गंधर्व ने इसे स्वरबद्ध किया है, बल्कि शब्द रचना भी उन्हीं की है। अब मैं आपके सामने एक मीरा का पद सुनाने जा रही हूँ। सानी हो मोरी नींदन सानी हो मोरी नींदन सानी हो मोरी नींदन सानी हो मोरी नींदन सानी हो सखी मोरी सखी मोरी मोरी नींदन सानी हो मोरी नींदन सानी मोरी नींदन सानी हो मोरी नींदन सखी मोरी मोरी नींदन सानी हो मोरी नींदन सानी मोरी नींदन सानी हो नींदन सानी सखी मोरी सखी मोरी मोरी नींदन सानी हो मोरी नींदन सानी पिया को पंथ निहारत सगरी रन बिहारी हो मोरी नींदन सानी हो मोरी नींदन सानी हो मोरी नींदन सानी सखी मोरी सखी मोरी मोरी नींदन सानी सब सखियन मिले सब सखियन मिले सीख गई मनाए कना मानी हो बिन देखा कल नाही परत दिया ऐसी घड़ी हो मोरी नींदन सानी मोरी नींदन सानी हो अब मैं आपके सामने दो निर्गुणी भजन कबीर के सुनाती हूँ। गिर चौबुती सिर उठे बसा रेणा रूप माया मलया गिर चौबुती सिर उठे बसा तीन लोक ब्रह्मांड खंड में देखे अंधर तमाशा त्रिभुवन मुक्ता डोले त्रिभुवन मुक्ता डोले उनका ज्ञान विज्ञान प्रकाशे। जब भी मैं ये लाइनें दोहराती हूँ, पंगुल मेरु सुमेरु उलंघे त्रिभुवन मुक्ता डोले गूंगा ज्ञान विज्ञान प्रकाश, मुझे हमेशा स्टीफन हॉकिंस की याद आती है जब भी मैं ये पंक्तियां गाती हूँ। पंगुल मेरु सुमेरु उलंघे त्रिभुवन मुक्ता डोले त्रिभुवन मुक्ता डोले गूंगा ज्ञान विज्ञान प्रकाशे गूंगा ज्ञान विज्ञान प्रकाशे अनहद वाणी बोले आकाश पताल शेष स्वर्ग पर राजे शेष स्वर्ग पर राजे कहे कबीरा राम है राजा कहे कबीरा राम है राजा जो कछु कर सोचा अंतिम 2 भजन सुनाती हूँ। दिल्ली में ऐसे मौके कम आते हैं कि जब मैं मराठी कुछ सुना सकूं। तो एक तुकाराम का छोटा सा अभंग सुना के उसके बाद में एक लोक भजन सुना के समाप्त कर दूंगी आज। चलेगा आपको? 10 मिनट का समय है। वल्लभा इसको अहिमोहिनी में किया है। वल्लभा लक्ष्मी वल्लभा दीनानाथा पद्मनाभा लक्ष्मी वल्लभा से तुझे पाई सुख वसे तुझे पाई माझा ठेवी तेची खाई लक्ष्मी वल्लभा लक्ष्मी वल्लभा लक्ष्मी वल्लभा सुख वसे तुझे पाई माझा ठेवी जमुना किनारे जमुना 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 किनारे मेरो जमुना किनारे मेरो सावरे भाई जयो सावरे 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 आई जयो सावरे आई जयो सावरे आई जयो सावरे जमुना किनारे जमुना किनारे मेरो सावरे आई जयो सावरे आई जयो सावरे आई जयो सावरे जमुना किनारे जमुना किनारे मेरो सावरे आई जयो सावरे आई जयो सावरे आई जयो जमुना किनारे मेरी ऊंची हवेली मैं ब्रिज की गोपिका नवेली मैं ब्रिज की गोपिका राधा रंजीनी मेरो नाम बंसी बजा के जइयो सावरे आई जइयो सावरे आई जइयो सावरे जमुना किनारे जमुना 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 किनारे मेरो सावरे आई जयो सावरे आई जयो सावरे आई जयो सावरे मली मली के आसनान कराऊं घिसा घिसा चंदन हो लगाऊं घिसा घिसा चंदन हो लगाऊं पूजा करूं सुबह माखन खा के जइयो सावरे आई जइयो सावरे आई जइयो सावरे न कन्हैया से बिछाऊं धीरे 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 सावरे आई जाइयो सावरे आई जाइयो सावरे आई जाइयो सावरे 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 आई जाइयो सावरे आई जाइयो सावरे जमुना जमुना किनारे मेरो सावरे बन जाइयो सावरे आई जाइयो सावरे आई जाइयो सावरे Thank you so much. You've been a
I thank Madam Kalapani and the accompanying artist for giving such splendid and enchanting performance. Ladies and gentlemen, the program for today now draws to a close. I request all the honorable dignitaries and our esteemed guests to proceed for the dinner on the deck on 8th floor. Secondly, please retain the badges for the next 3 days. Thank you so much. Namaskar. Should not come in between. Sorry. This was uncalled for. Excuse me. Wait, come.
Okay, you're coming to
मैम ने कहा
Because he pointed towards him on stage. Actually, the both of them are standing together.
We'll see her. We'll see her.
Yes, this location on the left. Yes, yes. And I think, upstairs. मुझे बहुत अच्छा लगा इसे ड्राई मैटर की बीच में आपने डाला
थोड़ा
थैंक यू जी कितना बाहर तो ठीक था आप अंदर का ये तो कर रहा था नहीं सुबह जरा करते हैं हम काफ़ी कोशिश कर रहे थे हमने जरूर भी था इसलिए थैंक यू सो मच मैम के साथ